A few months ago, we spoke with Senate Majority Leader Tom Bach and asked him what he thought should take precedence in the 2014 legislative session. He said one of the areas of concern is reforming the state's sex offender treatment program. And here to talk a little bit about the ongoing issues with that program, we have the Commissioner of Human Services, Lucinda Jesson. Thanks so much for joining us.
I'm delighted.
Commissioner, I would like to begin with this program. And as we were talking off camera and you mentioned earlier, there is a class action lawsuit to the state of Minnesota Department of Human Services, specifically talking about questioning the constitutionality of the state's sex offender treatment program. Why is it an issue?
Well, I think we have a number of different groups looking at the program and saying, how can we do a better job? The litigation itself is saying that they believe the program is unconstitutional in its treatment and particularly focused on the fact that there have been so few provisional discharges. But we also have a separate task force looking at the program and saying and recommending changes that would require legislative approval. And I think at the department level, we also are looking at saying, what changes do we need to make to improve this program, which does need change. We've started down that road and we have further to go.
According to an August 29th article in the St. Paul Legal Ledger, nearly 700 people are involuntarily detained at Moose Lake and the St. Peter facilities. This class action lawsuit that you referred to was filed 3 years ago. It's asking for several changes. What do you think some of those key changes need to be? What are you hearing from the task force thus far?
Well, let me talk about some changes that I think need to be made. Some of them are picked up in the litigation, but some of them are just my own assessment about what needs to be done. I do think we need more frequent assessments or risk assessments of the people who are there so we can make sure that they're in the right part of the treatment. And if they aren't and they need to be moved elsewhere, that we make those changes. That was part of the legislative proposal last session. I think we need to have options for judges when they commit people so that the only option isn't the most expensive option behind the razor wire. And that once again, I think that was something that was part of the legislation that passed the Senate but didn't pass the House last session. So those are two of the things that I think we need to do. Internally, I think also we need to speed up the process so that when someone petitions for a provisional discharge or just a change in their, to move to a less restrictive setting, that we handle those petitions more quickly.
Has there been any discussion, lengthy discussion, on how it is that the state got to where it is where virtually nobody, quote, gets out?
Well, I would just like to point out that we do have there was a provisional discharge, successful last year. That individual is living in the community. We have, I believe, about 2 more that are coming up to the courts. Because remember, the courts have to say that someone can be provisionally discharged. I can't just do this as commissioner, but we have 2 more people up that the treatment team supports for provisional discharge. And we have a lot more people in our final phase of treatment, twice as many as we did 2 years ago. So I think we're starting to see people progress through. But it needs to be a careful, thoughtful process. These are not decisions that anyone should rush into.
Is there any concern that if the standard for release becomes, and this is a quote from the article, much less stringent as requested in the court order, do you think public safety could be at risk?
Well, it depends what much less stringent is. But that is clearly a question for the legislature. You know, the standard is in law. It's being challenged, so a court could look at it and make a different decision about it. But I think Senator Bach was right, and that we need to look at this program and what changes need to be made.
And given that, how do you move forward with this? What is your timeline? Is there a sense of kind of expediency here, or does it need to be perhaps even more thoughtful and deliberative than what's typical?
These are serious decisions, whether to commit someone to begin with or whether to provisionally discharge an individual. And so I do think those need to be deliberate decisions. Any changes to this program should be thought through very carefully. But I think there are some things, while there's some things that the legislature needs to do to make changes, there's some things that as commissioner I can do to improve the program. And we are taking steps, thoughtful steps down that road, issuing an RFP so that we know who we could contract with for less restrictive options, speeding up this SRB process, which is this internal review board, having more assessments on a regular basis. Those are steps that, you know, I can take as commissioner, and I think are very appropriate ones to reform the program.
Commissioner, so how do you navigate this through the legislature, and is there a concern that if the legislature does not take appropriate action, that the federal government might come in and take this entire sex offender treatment program and run it itself?
Well, that certainly the program is being questioned before a federal judge. So, you know, there are certainly people who would advocate that the judge do that. I believe that particularly with the reforms we're making, the program is constitutional. I think that we can continue to improve it, and I want to work with the legislature to do that.
Okay, Commissioner Lucinda, Jesson, thanks for coming in and discussing this very important topic with us. We appreciate it.
Thank you.